Senate Committee on State Affairs will come to order. Will the clerk call the roll?
Betancourt, Birdwell, LaMantia, Menendez, Middleton, Parker, Perry, Schwartner, Zaffarini, Paxton, Hughes.
Here. Senator Alvarado, are you ready? Well, good morning. And the chair this time lays out Senate Bill 2171, 2171, first bill of the morning, and recognizes its author, Senator Alvarado, to explain the measure. Good morning, Senator.
Thank you, Mr. Chairman. I believe you're familiar with this bill. It's something that you carried once before. This bill aims to address an inconsistency in the Texas Civil Practice and Remedies Code by authorizing a chiropractor to offer expert testimony on the issue of causation in a chiropractic malpractice lawsuit. Under the current law, a chiropractor is not authorized to offer expert witness testimony on causation in a malpractice suit concerning chiropractic treatment. Civil Practice and Remedies Code Chapter 74 defines which healthcare provider may give testimony in a malpractice suit on the causal relationship between a claimed injury, harm, or damages and an alleged departure from the applicable standard of care. The statute currently authorizes dentists, podiatrists, and physicians to offer support testimony on causation in dental malpractice, but not chiropractors.
Thank you, Senator. Any questions for the author? Thanks, Senator.
Thank you.
We'll open testimony, and the chair calls Dr. William Lawson and Jack Walker. Dr. William Lawson and Jack Walker. Looks like they're both here. And we are on public testimony. To be clear, public testimony is open. If anyone wishes to testify on, for, or against Senate Bill 2171, please make your way outside of the kiosk and register there. Good morning. Introduce yourself when you get set up and give us your testimony.
Thank you. Good morning, Mr. Chairman and members. My name is Dr. William Lawson, and I'm here to testify in support of Senate Bill 2171 on behalf of myself, as well as the Texas Chiropractic Association. I am a doctor of chiropractic here in Austin, 30 years in practice, and I'm the current president of the Texas Chiropractic Association. I want to thank you all for the opportunity to be here and for all the hard work that you guys have done throughout this legislative session. Senator Alvarado, thank you so much for all the work you and your staff has put forth in this issue. Under current law, a chiropractor is not authorized to offer expert witness testimony on causation in a chiropractic malpractice suit, meaning a chiropractor can offer expert testimony on whether the chiropractor involved in the malpractice suit deviated from standard of care, but we cannot take the next step and opine whether that deviation from the standard of care caused the alleged injury. Instead, only a physician can offer expert testimony on causation in a chiropractic malpractice case. The law authorizes dentists to offer expert testimony on causation in a dental malpractice case and podiatrists in a podiatry malpractice case, but chiropractors cannot in a chiropractic malpractice case. This limitation is inconsistent with other areas of law. For example, in personal injury cases or a workers' compensation dispute, a chiropractor can offer expert testimony on causation. I know this may not be the most exciting issue that comes before the committee, and fortunately, it isn't a frequent one since chiropractic malpractice suits are really not that common. But for the chiropractor and the patient involved in a malpractice suit, it's really important that they be able to call upon an expert who is familiar with chiropractic technique and their impact on the human body. Senate Bill 2171 simply authorizes a chiropractor to offer expert testimony on causation in a chiropractic malpractice suit. To be clear, it does not prevent a physician from still offering such testimony. This bill ensures the plaintiffs and the defendants can call for a chiropractor's opinion on whether something a chiropractor did could have caused the alleged injury. Thank you, Mr. Chairman and members, for your consideration, and I'm happy to answer any questions that you may have.
Thanks, Doctor. Morning, Ms. Walker. Introduce yourself. Give us your testimony.
Good morning, Chairman. Mr. Chairman, members of the committee, my name is Jack Walker. I'm the Vice President of Legislative Affairs for the Texas Trial Lawyers Association, and I'm here to testify in support of Senate Bill 2171. A good portion of my practice is actually in medical malpractice, and in these cases, at the outset, a plaintiff must timely serve a defense counsel or an expert report that addresses not only the applicable standards of care, but the manner in which the defendants failed to satisfy these standards, and then a causal relationship. As it stands now in chiropractic cases, we have to get two experts. We have to get a chiropractor to testify with regard to their specific area, which is what we're dealing with, and then get a medical doctor just to make the causal connection. This bill only makes sense in that when we are dealing in chiropractic cases, the injuries are specific to the type of care that chiropractors treat. Because it's already accepted that they're going to testify as to the standard of care and identify the appropriate standards of care, that same expert should not be prevented from making that causal connection. It creates efficiency in litigation and cuts down on litigation costs at the beginning of the case, as well as throughout the discovery and through trial. And for this reason, we support the bill. We ask that it be reported favorably, and I'm happy to answer any questions.
Thanks for your testimony. Senators, any questions for either of our witnesses? Thank you both for being here. Is there anyone else present wishing to testify on, for, or against Senate Bill 2171? Seeing none, public testimony is closed. Bill's left pending at this time. The chair now lays out Senate Bill 1932, and recognizes Senator Paxton to explain the bill on behalf of its author, Senator Creighton.
Thank you, Mr. Chairman and members. And I'm happy to be able to lay this bill out on behalf of Senator Creighton. The wine industry in Texas has been steadily growing for years, with recent studies showing over $13 billion in revenue and over 100,000 jobs provided. It's important that we continue to encourage the growth of this industry. However, in Texas, it's currently not possible for a private wine collector to sell wine to a restaurant for on-premises consumption. Other states, such as New York, allow this practice. This leads to valuable Texas wine and revenue leaving the state. Senate Bill 1932 would allow for the sale of legally owned wine by wine collectors to certain permitted restaurants. The bill creates a new chapter of the Texas Alcoholic Beverage Code, Chapter 111. This chapter lays out the process through which someone can go through TABC to become a registered wine collector after completing a background check, paying a fee, and completing any other requirement TABC finds necessary. Once a collector, that individual may sell to any permitted restaurant in the state. Senate Bill 1932 has enforcement mechanisms laid out in the bill in the form of fines and allows TABC to adopt any other rules deemed necessary for implementation and enforcement. Thank you, Mr. Chairman. And Senator Creighton, if he were here, would be happy to answer any questions. There is also a witness.
Thank you, Madam Chair. Senators, any questions about the bill at this point? Very good. Well, open testimony. And the chair calls Colin Parrish. Colin Parrish, there he is. And also the chair calls Rachel Van Til. Rachel Van Til. And we don't have a preference in the order in which you go, so if y'all do, then y'all decide. Otherwise, we'll do ladies first. Go left to right. Whenever you get ready, introduce yourself, give us your testimony.
Excellent. Chairman, thank you so much for having me. My name is Rachel Van Til. I am an advanced sommelier with the Court of Master Sommeliers. I am in favor of this bill and testifying on behalf of both myself and the clubs at Houston Oaks, where I am employed. The wine industry is a big part of Texas culture. I've had the privilege over the last decade of working at wineries, restaurants, and now at a private country club that has a retail space, a restaurant, as well as houses the private collection of our members. So I've gotten to see the industry on all sides of how it operates. The fact of the matter is that most very fine wine is released at a very young age, far before it is ready to consume. It's designed to be consumed after proper storage, 3, 4, 5, sometimes as many as 10 decades after it was originally created. This bill simply allows for the wine to be enjoyed at the age in which it is reaching maturity. And as we look at the restaurant scenes across Austin, Dallas, and Houston, we're seeing these become nationally more and more relevant. And the fact of the matter is that markets such as New York City and Chicago, which allow for collectors to sell these wines and be purchased by restaurants, have a much more viable wine scene. And as we continue to grow the food scene, it only makes sense for us to be able to serve these wines in a state of maturity and keep that revenue within the state of Texas.
Thank you for your testimony. Good morning. Mr. Parrish, introduce yourself. Give us your testimony.
Thank you, Mr. Chairman, members. My name is Colin Parrish, and I'm here today to testify on behalf of myself in support of SB 1932 by Senator Creighton. Whether you're not a wine drinker, I expect you know that lots of people are passionate about their wine. And in a state with 30 million people, or more than 30 million people, Texas has its fair share of wine collectors. Now, people collect wine for a host of different reasons, whether it's the anniversary of a wedding to celebrate the birth of a child, or because, as Rachel mentioned, they have fine wine that they want to lay down and see it mature over a few decades. Now, at one point in a collector's career, they realize that they have either collected more wine than they could possibly enjoy themselves, or they die. In both cases, this wine has to find some place to go, and many times it goes to an auction house in New York City and ends up on the menus of New York City restaurants, not staying here in Texas to be enjoyed by Texans. So with that, I had the privilege to work a little bit with Senator Creighton's office while this bill was being drafted, and I believe it creates a responsible way for rare and collectible wine to make its way into restaurants in Texas and onto the palates of Texans And I thank you all for your time today, and I humbly ask your support for Senator Creighton's bill to keep these Texas collections in Texas for the enjoyment of Texans. Happy to answer any questions you might have.
Thank you. Senators, any questions for either of our witnesses? Ms. Mantel, Mr. Parrish, thank you both for your testimony.
Thank you.
Anyone else present wishing to testify on, for, or against Senate Bill 1932? Seeing none, public testimony is closed, and the bill is left pending at this time. The chair lays out Senate Bill 1034, and recognizes its author, Senator Middleton, to explain the measure.
Thank you, Mr. Chairman, members. Today I'm laying out Senate Bill 1034. Public nuisance is an ancient tort dating to the 12th century, approximately in England, and the genesis of it was basically, get the logs off the road, don't dump the trash in the stream. And this was originally created as a criminal writ to remedy actions or conditions that infringed on royal property or public access, such as public roads or waterways. And they were remedied by abatement of the action. Public nuisance claims largely went away as statutory and regulatory remedies to traditional public nuisance claims were added to the law over many decades and centuries until the second restatement of torts published in 1979, which broadened the tort of public nuisance to include unreasonable interference with the public right. This was a monumental change that allowed individuals to enjoin a public nuisance as a representative of the general public, as a citizen in the citizen's actions, or a member of a class in a class of action. So this definition has led to primarily government plaintiffs, governmental entity plaintiffs, utilizing the tort of public nuisance in court to address large-scale public policy issues that are matters traditionally reserved for legislative bodies like this one. And this is a clear separation of powers issue that improperly allows the judiciary to make policy decisions. Senate Bill 1034 bars public nuisance claims that seek relief arising from three areas. Number one, lawful actions. It's lawful is important there. Authorized under statute, ordinance, regulation, permit, order, rule, or other similar measures adopted by either federal government, federal agency, state agency, the state, or political subdivision. Two, where a claim has a statutory cause of action or administrative enforcement mechanism that already exists, meaning a remedy already exists under the law. Or three, a claim relating to manufacturing, distributing, selling, labeling, or marketing of a product. So that's a traditional products liability or DTPA claim. This bill does not impact in any way private nuisance claims or common nuisance claims that seeks to deter criminal activity such as gambling, graffiti, prostitution, and the list goes on. Further, if the government is allowing you to do something, or if the government has given you a permit to do something, whether that's a license or a specific statute authorizing you to do this, you cannot bring a public nuisance claim under this bill, Senate Bill 1034. However, it's very important to point out three things. This bill does not limit public nuisance claims, and this bill does not apply if an activity is not lawful, number one, if there is not a remedy available under any law. Three, it is not a product. So those are the main exceptions to this bill. And with that, I yield for questions, and I think we have a number of witnesses as well.
Thank you, Senator. Members, any questions for the author at this point? Very good, thank you. We'll open testimony and invited testimony the chair calls Lee Parsley. Lee Parsley testifying for Senate Bill 1034. Ms. Parsley, welcome. Introduce yourself. Give us your testimony.
Good morning, Mr. Chairman. Thank you. My name is Lee Parsley. I'm here on behalf of Texans for Lawsuit Reform. We're in favor of this bill. I wanted to spend my time with you to describe for you, if I could, or to respond, I think, to what you may be hearing about this bill around the halls of the Capitol. So I'll go through that fairly quickly, if you don't mind. There has been comment made that the Attorney General's office, which just settled the opioid litigation, needed public nuisance lawsuit, needed the public nuisance cause of action in that litigation. In fact, they did not plead the public nuisance claim in the opioid litigation. We've heard that the Attorney General felt like they needed it in the Google litigation. There are 5 Google lawsuits that we're able to find, none of which plead public nuisance on behalf of the state of Texas. We've heard the same about the TikTok litigation, that it was needed in the TikTok litigation. There is no TikTok litigation at this time that we can find. There's only a civil investigative demand under the Business and Commerce Code, does not mention the public nuisance doctrine. We've heard that it was necessary to win the tobacco litigation. In fact, the public nuisance claim was pleaded in the tobacco litigation, and the court held that it was an improper cause of action in that litigation and dismissed the public nuisance claim. We have heard that, potentially this bill violates the open courts provision of the Texas Constitution. But again, the Texas Attorney General's office only 6 months ago filed a brief in the Texas Supreme Court saying that you, the legislature, are essentially free to do things like this, which is to enact laws that affect the existing common law. So our state's Attorney General's on record, I think, saying that you're able to do exactly this. The point of this bill, in part, is to say that litigation like this has to be conducted at the state level on behalf of all the citizens of the state. And again, I think the Attorney General has agreed with that in briefing filed in the opioid litigation. The counties, I think, tell you they need this as well, but we've looked at a lot of county litigation, and for the most part, county litigation, when things are polluting the water or the air, are pursued under the water code, there is a remedy there for the counties to pursue. And so the bottom line of this bill is that it allocates the power between the legislature and the courts in the way that we believe is the correct allocation of power. If there are products or things out there that are injuring the public, many times, in fact all time, the legislature should cure that legislatively. It should not be left to a jury and a judge to decide what the public policy of Texas is. And that's the bottom line about this bill, is it returns to you the power to decide the policy of the state of Texas rather than having judges or juries do that. Thank you.
Thanks for your testimony. Senator Bettencourt.
Thank you for coming this morning. I'm going to be asking everybody these questions because I'm not a lawyer and I understand what's happening, okay? Specifically, there's a tort of public nuisance. That seems to be at the crux of all this. If I'm missing it, tell me.
That's correct.
Okay. Now, how long has it been there? What's it been used for? Okay. And why are you trying to eliminate it?
It has existed since the 12th century in England. It came to the United States.
This is like pre-Magna Carta.
It is correct.
Okay.
It came to the United States as part of the common law that we adopted here. It was used in England by the king to protect, to remove encroachments on the king's property. So it was a property-related tort. And it was used by the king to remove impediments that blocked the highway, things that the public had equal access to, common access for everyone. So if the people, we all have common access to the highway. If somebody's cart was blocking the highway, it was a public nuisance.
Royal parks, deer hunting, et cetera, whatever. That's what I'm assuming that's right.
It affected some commonly held right. Then the public nuisance cause of action was used to remedy, and the remedy was always the abatement of the nuisance. You have to remove your cart. So that's the history of common nuisance. It was that way in the United States until 1979, when a group of scholars who work at the American Law Institute rewrote what is called the Restatement of Torts. And when they rewrote the Restatement of Torts, they expanded this hundreds-of-year-old cause of action to say that any unreasonable use of property held by the public at large was potentially a public nuisance.
Okay, so now with that, as the background, I've seen the Attorney General use this, okay? There's been a series of high-profile cases. that have raised, or at least certainly have the ability to collect billions of dollars for the state of Texas. So if this tort is gone, what vehicle does the AG have to do what he's been doing successfully? Because he's not only suing the federal government successfully 85–90% of the time, he seems to have quite a record here on those tort cases.
We have gone back and looked at the Attorney General's litigation. The opioid litigation, the state of Texas did not plead the public nuisance doctrine.
What do they use?
They used the Deceptive Trade Practices Act. They said that the opioid companies were deceptive in their marketing of the opioids, and that is actionable under the DTPA, and that's what the state pursued. The Google litigation, the state has referred to the Google litigation we've heard. The state's filed 5 Google cases around Texas, one in New York and 4 in Texas, none of which reference the public nuisance doctrine.
Okay, to your knowledge, is
Senator Betancourt, hold tight if you don't mind. I'm sorry. While we're talking about this, we have a resource witness from the AG's office. Let's call them up and ask the questions to them and Mr. Parsley as well.
By your command, Chairman.
Thank you. Hold tight, Mr. Parsley. We don't want you to go anywhere. The chair calls Chris Hilton. Here's a resource. This stuff you're talking about, you're probably going to want to ask them later. Let's get it going now.
Okay, that's right.
And forgive me for interrupting. You ended.
No.
I was pouring my tea and you ended quicker than I thought you would. I'm sorry.
Anything to save time, because I just have to ask the same questions twice.
Thank you so much. Ms. Hilton, get situated there. Introduce yourself. Tell us who you represent, and then we'll have some questions for you.
Thank you, Chairman and members. Chris Hilton with the Attorney General's office as a resource on the bill.
Very good. Senator Betancourt.
Chris, okay, we established the history of the public nuisance tort, which I don't think you're going to disagree with, and we got up to 1979 with a generally a philosophical change. I asked the question about, are there cases that the AG uses this to when there seems to be some high-profile cases lately, opioid, et cetera. The TPPF gentleman said, no, you're really using the deceptive trade practices. So what say you?
Thank you, Senator, for the question. I think that Mr. Parsley's confusion on this point kind of highlights some issues with the bill and the way that it's drafted. It refers to a tort of public nuisance, in assuming that that is an independent, standalone cause of action. Under Texas law, it's really a theory of damages. It's a theory of recovery. And so while Mr. Parsley may not have been able to find a separately pled cause of action for, quote unquote, public nuisance, it does not mean that public nuisance was not an important theory in any of those cases. It absolutely was important for the recoveries in the tobacco litigation, in the opioids litigation. The local subdivisions did explicitly rely on public nuisance theories in the opioids litigation, as I understand it. And between just those 2 pieces of litigation alone, the Attorney General's office and AG Paxton have recovered billions of dollars for the state. For tobacco litigation, it's hundreds of millions of dollars for taxpayers every year flowing into the state. So those are significant recoveries where public nuisance theories are a key piece of the litigation. It's also arisen in a Juul settlement, which was recently announced, and we use it for things, even localized issues such as illicit massage establishments. We're going after them under a public nuisance theory to combat human trafficking, because that is a legal tool that's available to us that's very valuable.
So you use the public nuisance tool to go after human trafficking.
Yes, Senator.
So how exactly?
So, in the context of an illicit massage establishment, a massage parlor that may be participating in human trafficking and sex trafficking, it is often it's a very valuable tool in the fight against those kinds of businesses, because they are a public nuisance. That's something that we can use as a legal theory to get immediate relief against certain defendants and those businesses that are condoning those practices.
Okay, do county attorneys, do district attorneys, do private individuals, do they have the right to use this? And are they doing so at this point?
So, Mr. Parsley is correct. This is a very old tort. It has been around a long time. predates the Texas Constitution, certainly. What I've heard in other testimony, particularly in the House and other people discussing this bill, is a parade of horribles that could happen if this tort is not reined in. And that has not been what we've observed and not what A.G. Paxton has observed. What we've seen is that this legislature has done a good job of limiting in the areas where this is subject to abuse. It's not a tool that we see as commonly used to have these negative consequences.
Okay, I'm going to ask both of y'all the same question. All right, so you've got a tort of nuisance that predates the Texas Constitution. Because of that, I assume that there's going to be other states that may have a problem. So is there a constitutional issue with this, for both of you, and have other states done this, and do they have any type of issues either? Again, I'm trying to understand what's the tool used for, okay? And, and why we're eliminating it, because that's, as a non-lawyer, that's what I'm trying to understand.
To my knowledge, Senator, other states have not eliminated the tort in this way.
To your knowledge, what?
The other states have not eliminated the tort in this way, to my knowledge. The constitutional problem posed here is a Texas constitutional problem. It's about the open courts provision. And essentially the legal issue there is that common law damages measures cannot be limited by the legislature under the case law as it currently stands. Now, Mr. Parsley is correct that our office, thinks that line of case law should be reexamined. But as the case law currently stands, there's a serious constitutional issue posed by the bill as it's currently drafted.
Mr. Please.
I'm sorry, it's going to take me a couple of minutes, but if you'll bear with me.
At the chairman's discretion.
I have the state's opioid petition in front of me. The word nuisance is never mentioned, either as an injury or a cause of action or a remedy or whatever you want to call it. It is not in this document. They do not plead the word nuisance in any sense in the opioid cases. It's not in their pleading. I don't know how it can be critical to the resolution of a case when it's not even in your fundamental document in the case. It's not in the pleading. It's not in their Google pleadings. There is no TikTok lawsuit. In their TikTok civil investigative demand doesn't talk about nuisance. The tobacco case, here I'll just read you what the court, the overly broad definition of the elements of public nuisance urged by the state, this talking about the state of Texas, is simply not found in Texas case law. And the court is unwilling to accept the state's invitation to expand a claim for public nuisance beyond its grounds in real property. Accordingly, the court dismisses count 10 for public nuisance. In the tobacco litigation, it was a loser. They lost it in tobacco litigation. They did win money in the tobacco litigation, unquestionably, under the Deceptive Trade Practices Act, but the public nuisance doctrine was a failure. It is not you are not in this bill eliminating the tort of public nuisance. What you are doing in this bill is confirming the tort of public nuisance as it has existed for 700 years. It has always been a property-related tort that they are seeking to expand to other things. But importantly, the Attorney General is not using the public nuisance lawsuits in any public document that we can find. We have looked at them all, and they are not pleading it. They are not alleging that nuisance is either an injury or a remedy or a cause of action or an anything. It is not in their pleadings. The state of Oklahoma, to try to answer your question, no other state has done this by statute, but the state of Oklahoma in the opioid litigation about 2 years ago said, in response to the opioid litigation under public nuisance, it does not apply. That's not what the public nuisance tort is about. It doesn't apply to opioid cases. The state of West Virginia, in the same thing in opioid cases, said, the federal court in West Virginia said, it doesn't apply. That's not what the public nuisance doctrine is. So yes, it is true that counties and cities are pleading the public nuisance doctrine. It is true they plead it in the opioid case, but they're not winning it. Those cases are resolving for lots of reasons, but they're not winning the public nuisance claims. They make the public nuisance claims, and they have a lot of leverage in those lawsuits, and the lawsuits settle. But settling the lawsuit is not the same thing as admitting the claim was valid. So that's where it's left, is you've got this idea that public nuisance exists because the defendants say, I want to pay off and get out of this case. The opioid defendants, lots of them needed They were they were bad actors, and they needed to pay up. And they recognized that, and they did. And the fact that there were claims asserted does not mean the claims were valid. It just means the claims were asserted. Human trafficking falls under Chapter 125 of the Civil Practice and Remedies Code, which is a nuisance statute. It's got like 20 items in it that you can abate as a nuisance. It includes prostitution, gang activity, all that kind of criminal activity that the counties, cities, and the Attorney General can all seek an abatement of those nuisances under Chapter 125. It's not the same thing as the 700-year-old tort of public nuisance. So you're not eliminating anything, which is why there's no constitutional problem. You would be codifying 700 years of law to say that here's the rules for the road for public nuisance. And the reason it matters to you is because the jurisdictions, Harris County, Dallas County, the jurisdictions that you might be concerned about, Senator, can use this cause of action to literally regulate society. They can decide tomorrow that hamburgers cause obesity, and so they're going to sue fast food franchises out of business for billions of dollars. They can just claim it and say, look, this cause of action exists, we think, so here it is. They can use it to sue windmills out in the country because they could say, we have a public right to see the landscape ahead of us, but the windmills make our view no good. They ruin our view, so therefore a windmill is a public nuisance. We want to bring a public nuisance lawsuit to remove all the windmills. It is literally limitless what it can be used for unless you do something about it. If windmills are a problem, you should introduce a bill. If fast food is a problem, Senator Perry should introduce a bill, right? It is your province to regulate society that way. It is not in the province of the jury.
Well, Mr. Parker, while windmills may be my problem, fast food is not Senator Perry's problem.
I understand. Okay. But you're not eliminating a tort. What you're doing is you're saying the tort has existed this way for 700 years, and we want to continue for it to exist this way.
Chris, can I get a response?
Of course, Senator, and I apologize. I'm just pulling up the text of the committee side, which I have right here. Several things to respond to there. First, with respect to the parade of horribles that Mr. Parsley is alluding to here. The fact of the matter is this tort is centuries old, and we haven't seen that. We haven't seen it abused in the state of Texas, and in areas such as perhaps there's an oil derrick offshore that explodes or causes some sort of damage. The legislature has stepped in to address those issues and ensure that municipalities are not doing things on behalf of the state that are more properly done by the state. So where this has been an issue, the legislature has stepped in, and we've seen that. With respect to, Mr. Parsley's contention that this bill doesn't eliminate anything, that's not the text of the bill as we understand it. And in fact, it is very broad in its carve-outs from public nuisance theories. The first carve-out, this is 100C.002 subsection A1. It provides essentially immunity for any action or condition that is authorized or approved under any kind of license or permit. And so a condition authorized by a permit, that could be a business license, that could be a certificate of occupancy from a local municipality. The immunity from a public nuisance theory is incredibly broad that's conferred by this. So I respectfully disagree with Mr. Parsley that this doesn't take away anything. Mr. Middleton, or Senator Middleton, excuse me, when you were explaining your bill at the front end, you mentioned the restatement of torts. And I think it's important that I mention that the restatement of torts is not the same as binding case law in Texas. I'm not aware of any case law in Texas that adopts the restatement of torts, that requires the restatement of torts be followed. And so the overbreadth issue that you're concerned about when you're looking at that provision of the restatement of torts, that doesn't necessarily have any correlation to Texas law. So again, to the extent that Mr. Parsley is suggesting this isn't eliminating anything, I don't see how this bill can be fairly read to be aligned with that. The other thing that I wanted to respond to is, again, this assertion that because the word nuisance doesn't appear in whatever pleadings Mr. Parsley has looked at, that this isn't in fact an important tool for the Attorney General. It absolutely is, and Mr. Parsley's assertion that just because A.G. Paxton may not be pleading something or may not assert a particular cause of action, that we could reach the same recoveries through other means, particularly for the opioid settlement. I think Mr. Parsley said that that case resolved for a lot of other reasons, completely unrelated to the claims of public nuisance that were brought, particularly by the local subdivisions. That simply is not how litigation works, quite frankly, when we're talking about complex litigation with multiple parties trying to address, serious harms to the state of Texas. The leverage of a public nuisance claim and a public nuisance damages model increased the amount of money that's available to this legislature to ameliorate the opioid epidemic. So when the fiscal note says that there's no direct cost to the state, I understand why it says it that way. But as a litigator who's worked on the opioids case, who's worked on the tobacco case, who's worked on many of these cases, what I can tell you is that having this tool in my toolbox allows me to get more money for Texans. And that's just how litigation works. The more claims you have brought, could bring, I don't know what pleadings Mr. Parsley has looked at. There's certainly lots of non-public discussions, drafts, theories that we're working on that Mr. Parsley wouldn't be privy to. And I, am absolutely confident telling this committee that public nuisance is a key part of many of these issues. But it increases the amount of money we're able to recover for Texans. So.
Well, I wish you gentlemen were both on the same side because I'd be completely convinced.
I just, let me say, I just don't know how. I did litigation. I'm a almost 35-year lawyer. I worked at big law firms, did litigation forever. I'm not stupid. I'm not misinformed about litigation. You plead your case, and it's a public record. And you use that pleading as a basis for negotiations, and you use that pleading as a basis to resolve your case. And you always plead broadly. People plead everything they think they could possibly apply. You throw in the kitchen sink. No one pleads nothing and then negotiates it that I know of. It's not, you do the opposite. You plead broadly and then you pare things down in your negotiations. You say, well, okay, maybe you don't like my public nuisance claim, but I still got you on DTPA and you owe me $3 billion, right? No one does it the opposite.
Right, there's always a gotcha. That's what you're looking for. Right. So let me just, one last question then, so I understand. So you're saying that the carve out the bill that carves all this out, okay, does not affect that negotiation that you just explained? Because that's the key point that I'm trying to understand.
That's correct. I'm saying that the state is not relying on the public nuisance doctrine to bring in a recovery in opioids and tobacco, at least not on the face of the public record, and it doesn't make sense to me that it is somehow the key element to these negotiations when it does not exist on the face of the public record. And they lost it in the tobacco case. And Oklahoma has said it doesn't exist as a cause of action in opioid. West Virginia federal court said it doesn't exist. And I've got all of that material for you, Senator Bettencourt, which we're happy to provide to you.
Sorry, you've been a little busy lately.
Yes, of course.
I get dragged in as the caboose on these fights. Okay, so thank you for your comments. Chris, same response. If that's carved out, I assume you disagree?
I do, Senator, and I've been involved in negotiations on the opioid cases, whether the local subdivisions did plead public nuisance theories, public nuisance damages, whether something appears. I just simply disagree with Mr. Parsley as a matter of litigation strategy, and I can tell you that the public nuisance theories were important and increased the recovery we were able to get for the state of Texas.
Well, but the state, Texas filed, United States Supreme Court for the Sixth Circuit. Texas joined a brief with many other states, and they urged the Sixth Circuit to kick the local subdivisions out of the case, to don't let them pursue the case.
What year, Mr. Marks, roughly?
What year was it?
Yeah.
The brief was filed.
I believe he's referring to the opioids litigation that's ongoing in Ohio. There is a national opioids deal. There's also a state-specific Texas opioids deal. And when we talk about opioids litigation, there are multiple different pieces of litigation ongoing, and so you can't really, we're both talking about them holistically, but it's much more complicated than that, and you're talking about dozens of petitions filed within Texas and across the country that we're dealing with. So Mr. Parsley, referring to whatever pleadings he's referring to, is not the entire picture of what's happened in that litigation.
I get it, but I'm just telling you the state's position in the United States Sixth Circuit Court of Appeals in September 6, 2019 was this. the local governments do not and cannot, by their nature, serve the role that the state as a sovereign serves to protect the interests of all communities of Texas. They asked the Sixth Circuit to not recognize the cities and counties lawsuits because they complicated the litigation and they were unnecessary. And yes, it was in the federal MDL, not the state MDL, but the state's position 3 years ago was all these public nuisance claims by the cities and counties was an impediment and the wrong way to do it, and it impeded the constitutional right of the AG to represent their states.
Well, Ms. Parks, I just want to y'all recognize one thing. 20 years ago, there was a tax assessor, a state representative, and a future lieutenant governor who were the only three people that were brave enough to stand up and say that we were for tort reform publicly in Harris County. So it's very important that I understand what we're doing because we've had a 20-year fight to make sure that we get it right. And there's been no other proponent of the office's success of fighting the AG, fighting the federal government, and fighting on these other issues than I think I've been publicly down in Harris County as well. So that's why I'm asking these questions, because it's very important to make sure we get the actual law right, because as you know, counselors, bad facts makes bad law. So that's why I'm trying to understand at this point.
Yes.
So thanks you for your time. I appreciate the questions.
Thank you, Senator Bettencourt. Senator Perry.
Thank you, Mr. Chairman. So I'm not an attorney by choice. I thought about it in 61 years of age and 42 years of other practices. I'm glad I didn't. I don't have the patience for it because I find that you can argue any perspective the way you want it to be. I'm going to use my very West Texas layman viewpoint right now. What I hear from your perspective is it's not needed. In fact, it can be an impediment at the wrong jurisdiction. However, I hear on the AG side, it's a tool we use even though we don't document it, that we use it. Fair statement?
I would just disagree with that last piece, that we don't document, that we use it, whether it
So
appears.
can you produce the examples, any one of the examples where you have actually documented the use of that doctrine? Not in conversations, not in some closed door negotiations, but can you show where you do it? And before you answer that, what I'm hearing is y'all want the use of it, and that's okay if it's effective. I'm not arguing for or against this right now. You want the use of it, but yet, and let me ask it this way: would you be set? Does the AG's processes or opinions or outcomes from it come from? Does it set precedent? I mean, how y'all win cases, is that a precedent-setting event, meaning the locals could look at that and go, they used that doctrine and build y'all into their conversation? Are y'all a precedent-setting agency? I'm not an attorney, but do y'all's wins and losses set precedent for courts to go forward with? So 2 things. Can you produce something in writing on any one of those examples that's been given? And I'm not saying that's the deal breaker. I'm just saying I think it's a valid point because attorneys get paid for time, and the more you write down, the more time you get to bill for. So what's the response?
Well, on that point, Senator, as a government attorney, I don't get paid for my time. I get paid for our results. And the Attorney General absolutely sets precedent in the results that he produces for the state of Texas. Attorney General Paxton produced billions of dollars for the state of Texas in the opioid case. And the local subdivisions absolutely did plead public nuisance theories. And the idea that just because the word nuisance doesn't appear in whatever pleading Mr. Parsley's looking at, that doesn't mean that it wasn't a key part of what we accomplished there on behalf of the state. We worked with the local subdivisions to achieve that result for Texas. And when you remove a tool from the toolbox, it reduces your leverage as a litigator. I am happy to go back and look through other public documents to see if I can find one that explicitly refers to nuisance in the way that Mr. Parsley's suggesting. Again, I would highlight that a standalone tort of public nuisance it's not a standalone cause of action, it's a damages theory under Texas law. And so it's completely unsurprising to me that that word may not appear in a complaint or a petition. That's completely unsurprising to me. And that doesn't mean that we are not taking a broad and aggressive approach to maximize our litigation leverage.
Does your
but I'm happy to go back and look.
Does your broad and aggressive approach encourage frivolous suits by the locals on other matters?
So my opinion, certainly that's an appropriate and legitimate area of concern for the Senate and for this body. And so as a policy matter, I'm not going to comment on that. What I can say is that in the examples where Attorney General Paxton has produced results for the state of Texas, that hasn't been the case. And I can say, just in my experience as a litigator within Texas, this parade of horribles that Mr. Parsley is suggesting just hasn't occurred with the tort and the theory of public nuisance. And when I look at the breadth of the exemption and immunity that is provided with the text of this statute, it is quite broad and really could take this theory completely off the table for any business. And I don't think it's correct to say that the Attorney General would necessarily have equal substitutes such that this wouldn't have any effect on the amount of recovery that the Attorney General Paxton is able to get for Texans. So, for example, I think Mr. Parsley mentioned the DTPA, the Texas Deceptive Trade Practices Act. Of course, Texans for Lawsuit Reform is against that act in principle anyway, but leaving that aside, the DTPA has a very different measure of damages, different things that we must prove. In fact, the state does not recover damages under a DTPA action. It can recover penalties. It can enjoin conduct. Other versions of this bill have been specifically targeted at limiting what the AG can recover. To suggest that the DTPA is a clean substitute and would give us the ability to give Attorney General Paxton the ability to recover almost $3 billion from the the people responsible for the opioid crisis, that's simply not correct. Having all the tools in the toolbox is what allows us to maximize our recoveries.
Okay. Well, and I'm with Senator Bettencourt, two groups that I highly, and people, individual people, I have high regards and respect for. It puts us in a really precarious situation, and it's almost untenable at some level because there's a piece missing here, and it may just because it's dealing with people. And if it's people that's the piece that we can't figure out, then maybe we don't need to figure it out. But it's a real mess.
And if I can just say, Senator, I absolutely respect Mr. Parsley as well. And while we obviously vehemently disagree on this particular issue as far as what the effects of this bill would be, perhaps that is, all I can say is on behalf of Attorney General Paxton, this is an important tool in our toolbox for past fights, for future fights, for ongoing things that we are looking at that Mr. Parsley is not going to be privy to protect Texans, to maximize recoveries for Texans, to generate money for this legislature to ameliorate harms caused by businesses in Texas. And so I think we just come at this particular bill from different perspectives in that regard.
Senator Perry, may I just quickly address?
Mr. Parsley, quickly.
All right. So the Attorney General's office is saying to you that this is not a cause of action, and so therefore they don't plead it, is essentially what I think I'm hearing. But in the same breath, he says, but yes, the cities and counties did plead it. So I have in front of me Harris County's pleading in the opioid litigation. First cause of action against all defendants, public nuisance. They plead it as a cause of action. Now, you can't recover on a cause of action that you don't plead, and they don't treat it like it's some nebulous remedy injury thing. The counties pled the cause of action. The state did not. So they're here telling you today that we're not pleading it because it's not really a cause of action, but we're using it. But that is not how the counties view it. They plead it as a cause of action. They treat it as something they have to plead to recover under. So I can't explain for you why the state's position is that this thing exists, but not as a cause of action, but it helps us. It doesn't make sense to me. I can only look at the public record. We agree the Attorney General has recovered billions of dollars for the state in the opioid litigation. We agree with that. He just did it under the DTPA, and it was his pleading, and on the face of the record, that's what we know. is it was a DTPA pleading and a successful litigation strategy. That's what we know on the face of the record, and we know that counties treat public nuisance as a cause of action.
One final question, and I'll turn it back over. I guess I am the chair currently. So that's a valid point, because if the target is nuisance from a lower than in the AG's office perspective, and I think I hear that we don't want all these fires burning all the time, and I hear your response is it's up to the legislature to produce statutes that prohibit that. But let me ask it this way. Would you have been successful, and I think I have the answer, but specifically if those local jurisdictions had not argued the public nuisance doctrine, what would you have been different in your approach to that case?
I don't want to go, thank you for the question, Senator. I don't want to go too far into non-public issues because I don't want to
it's a simple question.
Confidences, but I understand the question.
You're saying this is a valuable tool in your toolbox, even though not formally anywhere documented, and I get it. You use the theory, right? You use a lot of theories. You may not have wrote down every theory you employed. Had it not been for the public nuisance argument in these local jurisdictions, what would have been different in your approach?
What I can say is, in my view, the Attorney General Paxton having public nuisance as part of this effort to maximize our recovery from opioids,
I guess to be more direct,
was able to increase the recovery for Texans.
To be more direct, if not for a public nuisance doctrine at the local level, would you have been more aggressive in employing a public nuisance argument and successful?
I just don't want to comment on litigation strategy decisions in a public forum. I'd be happy to go into detail with you on that. But what I would say is simply because Harris County pled it with a heading that says public nuisance in the heading doesn't necessarily have any legal effect whatsoever with respect to our friends in Harris County. I think the Attorney General's office has the finest lawyers in the state, and so we can disagree about how to plead things. But that does not mean that public nuisance was not a key piece of this litigation.
Thank you. Any Senator Milton question? We've got what we go on.
A lot more witnesses.
So we're going to probably need to break in about 5-10 minutes. Okay, we got about 5-10 minutes here before we have to break for session. Clean this table off.
Okay. You know,
11:40.
You know, from the litigation perspective, I keep going back to the fact that if it's the cornerstone of a recovery, if it is critical to the success of the case and essentially it will collapse without something, why would you not plead that? You know, I mean, that's what I keep coming back to. And, you know, it has been pled before by the state. So in the tobacco case, it was pled and it was thrown out, and the court said this overly broad definition of the elements of public nuisance urged by the state is simply not found in Texas case law, and the court is unwilling to accept the state's invitation to expand a claim for public nuisance beyond its ground and real property, which is what we talked about in the layout. You know, we're the genesis of public nuisance, and the court dismissed it. So I guess that's really my question. If it's so important, then why not plead it? I mean, trial lawyers always, you know, when there's an injury, you ask for everything and then the kitchen sink and then some, right? I mean, do you ever deliberately not ask for damages? You know, I mean, do you throttle back what you ask for damage? No, I mean, you ask for as much as you can think of and as much as reasonable in your mind as a defendant and or plaintiff, either one. So. Anyway, I guess that's my question is why would you choose not to plead it?
Yeah, Senator, I understand the question. I appreciate it. And thank you for the opportunity to kind of clarify what I'm saying. If I said that this was a cornerstone of what we accomplished and what the Attorney General Paxton accomplished with the opioid settlement, then I misspoke. What I intended to say, what I think I said, was that this was an important tool in the toolbox. And it increased the amount of recovery that we were able to obtain. The more tools that we have in the toolbox, the more money we're able to obtain for Texans to, in this case, ameliorate the opioid crisis. I would respectfully disagree with you, Senator, that in every case it is appropriate to plead every theory in every pleading from the jump. There are strategic considerations that come into play in complex pieces of litigation that have nationwide impact. We make decisions all the time about what claims to bring and what claims not to bring for all kinds of strategic reasons. And so, again, I certainly understand and appreciate the point that Mr. Parsley is making, but the reality of it for pieces of litigation like we're talking about, where the Attorney General's office would be involved, they're much more complex than a more common tort that everyday people may encounter, a car accident or some other kind of tort where, yes, usually the upright approach is going to be a broad pleading approach. We make decisions every day about what to plead and what not to plead for a variety of strategic reasons. And so I'm not at all trying to say that this was a crucial piece without which opioids wouldn't be possible. That would be overstating it. But I feel very comfortable saying that it's an important tool in the toolbox and that it does increase the amount of recovery that we're able to obtain for Texans. And limiting that, I don't want this committee or you, Senator Milton, to read too much into the fact that the word nuisance may not appear in a particular pleading. The reality of litigation like this is that it's much more complicated than does a word appear in a pleading as to how these things play out in negotiations.
Right, and obviously this is not eliminating the tort of public nuisance. It's not doing that. It's just
All right.
It's limiting it to situations in which the activity is lawful. There's a remedy available elsewhere when it's a product.
We're going to have to wrap it up. You two gentlemen probably need to plan on packing a lunch. We'll be back, I believe, 15 minutes after Senate floor adjourns. So with that, I need to recognize Senator LaMattia is present, Senator Safaridia is present, Senator Paxton. I wasn't sure if you're on the original roll call. All right. With that, we're staying in recess subject to 15 minutes after adjournment of the Senate floor.